Throughout the United States, there is growing social awareness that sexual violence and harassment are far too common occurrences within our various institutions, occurrences often without any accountability.
Often? How often is often? And our various institutions seems a bit generalized. And I want to make note that sexual violence and sexual harassment are two entirely different things. For some reason, I have a feeling that distinction needs to be underlined before we proceed.
As a result, the Me Too movement is upon us, and survivors everywhere are speaking out to demand change. Students have rallied against sexual assault on campus.
Yes, students have rallied against sexual assault on campus, even when the allegations of such were entirely fictional, which only emphasizes the need for evidence ahead of believing or reacting in protest over an allegation.
Service members have demanded Congress reform the military, and workers ranging from Hollywood stars to janitorial staff have called out sexual harassment in the workplace.
And they have every right to do so. There's no argument here. Though, the threshold for what qualifies as sexual harassment has become so nebulous these days, and the reactions to mere allegations have become so zero tolerance, that people, primarily men, are running scared in having even the most benign interactions with the opposite sex. But then, maybe that's the point.
This is a tipping point. This is when a social movement can create lasting legal change, but only if we switch tactics. Instead of going by institution, fighting for reform, it's time to go to the Constitution.
The Constitution? So you want to amend the Constitution in order to, what? Make sexual assault illegal?
As it stands, the U.S. Constitution denies fundamental protections to victims of gender violence, such as sexual assault, intimate partner violence, and stalking.
The Constitution denies protection against gender violence, and gender violence includes sexual assault, intimate partner violence, and stalking. All right. Where? Where does the Constitution deny such protections? Where does the Constitution say, "Thou shalt make no law criminalizing sexual assault"?
Specifically, the 14th Amendment of the Constitution, which prohibits state governments from abusing its citizens, does not require state governments to intervene when private parties abuse its citizens.
What? Okay, let me read the part of the 14th Amendment that is the most relevant here. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. How is ensuring the accused is provided due process of law and ensuring that all people are entitled to the protection of the laws mean that the state is not required to intervene when its citizens are abused in violation of the law? What are you talking about?
So what does that mean in real life?
I'm not 100% sure that you are operating in real life.
That means that when a woman calls the police from her home, afraid that an intruder may attack her, she is not entitled to the state's protection.
If someone has broken into your home, which is a crime, and the threat exists of further crimes taking place, and the Constitution says that the state cannot deny people the protection of the law, how are you not entitled to the state's protection? Did I just step into some alternate version of reality or something?
Not only can the police fail to respond, but she will be left without any legal remedy if preventable harm occurs as a result.
What? Amending the Constitution will ensure that police will always respond to such calls and/or always respond to them in a timely manner? That doesn't make any sense. Now, to her second claim, she does have a bit of a point. The Supreme Court ruled in 2005 that police do not have a constitutional duty to protect anyone. Quote, even a woman who had obtained a court-issued protective order against a violent husband, making an arrest mandatory for a violation. So, is that what our speaker is asking for? An amendment to overturn the 2005 decision, even though the decision applies to all crime and not just sexual assault? I'm really confused as to where this is going.
How can this be? It is because the state, theoretically, acts on behalf of all citizens collectively, not any one citizen individually.
That's because the state is a collective entity. The state operates on behalf of its people as a whole. The state does not represent one person, unless we're talking about a tyranny. This is why criminal cases are usually headlined "The People versus Joe Smith" or "The State versus John Doe." Our speaker wants the state to start representing the individual? I am dying to know how that concept would affect our system of justice.
The resulting constitutional flaw directly contradicts international law, which requires nation-states to intervene and protect citizens against gender violence by private parties as a human right.
You still have not shown me that the Constitution denies protections against sexual assault.
Unlike what you may have seen on Law & Order SVU, justice is rare for victims of gender violence.
How rare is rare? Are you going to provide us any numbers on that? No? Okay. And, by the way, how do you know that a defendant not being convicted isn't justice against a false accusation?
And even in those rare cases where law enforcement has chosen to act, victims have no rights during the resulting criminal process.
Victims have no rights in the criminal process. Well, I am not a legal expert, so maybe in some sense she is correct. But here is my layman's reaction to that statement. Determining whether someone is a victim and if the other person is a villain is the process. And we don't want accusers having direct powers in criminal prosecution. The state and our laws are the buffer to help ensure a fair trial, because anything else would be akin to vigilante justice.
You see, victims are not parties in a criminal case. Rather, they are witnesses, their bodies evidence. The prosecution does not represent the interest of a victim. Rather, the prosecution represents the interests of the state.
Okay, so again, you want to do away with our criminal justice system entirely, remove the impartiality of the process, and have the government directly represent individuals instead of the laws of the land in criminal trials, but specifically in sexual assault cases. Got it.
And the state has the discretion to dismiss criminal charges, enter lax plea deals, and otherwise remove a victim's voice from the process, because again, a state, theoretically, represents the interests of all citizens collectively, and not any one citizen individually.
Criminal justice is meted out by the state on a collective basis in an attempt to see that the laws of the land are applied fairly to all defendants. The state and its laws, enforced on behalf of the people, is how a civilized society works. But you want individual accusers to have legal discretion over the prosecution of the accused with the power of the state at their personal command? This is beginning to sound like the plot to some Netflix series about a dystopian future.
Despite this constitutional flaw, some victims of gender violence have found protections under federal civil rights statutes, such as Title IX.
Despite this constitutional flaw. Our speaker has used that phrase a couple of times now. So, the flaw in the Constitution is the mechanism of state sovereignty? I'm confused.
Title IX is not just about sports. Rather, it prohibits all forms of sex discrimination, including sexual violence and harassment, within educational programs that accept federal funding.
Golly, and this whole time I thought the Constitution denied such protections. I wonder where I got that idea.
As it stands, the U.S. Constitution denies fundamental protections to victims of gender violence. So what this means is that through Title IX, those who seek access to education are protected against gender violence in a way that otherwise does not exist under the law.
Under the law? Under which law? The state laws? Please list for me which of the 50 states does not criminalize sexual assault. And if you mean federal law, well, isn't Title IX a federal statute, i.e., federal law? Oh, but that only applies to schools which are accepting federal money. Otherwise, there are no other federal laws pertaining to sexual assault, right?
Right.
Is that what I am to understand?
It is Title IX that requires educational institutions to take reports of gender violence seriously or to suffer liability. And through campus-level proceedings, Title IX goes so far as to give victims equitable rights during the campus process, which means that victims can represent their own interests during proceedings, rather than relying on educational institutions to do so.
Yes, but those are not criminal proceedings in a court of law, but disciplinary proceedings in an educational institution. I am still trying very hard to believe that I am not understanding our speaker to be advocating for what it sounds like she is advocating for, because it is madness.
And that's really important, because educational institutions have historically swept gender violence under the rug, much like our criminal justice system does today.
Really? Our criminal justice system sweeps such things under the rug? Do you have any evidence of that you would like to present? No? Okay.
So while civil rights protect some victims, we should want to protect all victims. Rather than going institution by institution fighting for reform on campus, in the military, in the workplace, it's time to go to the Constitution.
Okay, so Are we finally going to hear what it is that you want to change about the Constitution? What brilliant amendment will finally stop sexual assault from being totally legal in the United States? Well, lay it on me.
And pass the Equal Rights Amendment.
The Equal Rights Amendment, which states, in its most relevant passage, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The Equal Rights Amendment, which has been floating around in Congress since 1921. The Equal Rights Amendment, which, in the late 1970s, gained 35 of the necessary 38 states of support needed to ratify it, before Phyllis Schlafly gathered enough support to halt the process, since the amendment would, by her reckoning, disadvantage housewives and cause women to be drafted into the military. But now, the Equal Rights Amendment is going to create a new legal process by which an accuser may wield the power of the state to prosecute the accused in sexual assault cases. That is what the Equal Rights Amendment is going to do. Got it.
Originally proposed in 1923, the Equal Rights Amendment would guarantee gender equality under the law.
1921. It was first introduced to Congress in 1921.
And much like Title IX on campus, that constitutional amendment could require states to intervene and address gender violence as a prohibited form of sex discrimination.
It could do that. So it might not. So this amendment isn't necessarily a solution to the problem that you are speaking about. Got it.
While the Equal Rights Amendment did not pass in the 1970s, it actually came within 3 states of doing so. And within the last year, at least one of those states has ratified the amendment because we live in different political times. From the Women's March to the Me Too movement, we had the growing political will of the people necessary to create lasting legal change.
Right. There have been no federal laws created specifically to address sexual violence, because the Constitution
denies fundamental protections to victims of gender violence.
Got it.
So as a victims' rights attorney fighting to increase the prospect of justice for survivors across the country, and as a survivor myself, I'm not here to say time's up. I'm here to say it's time. It's time for accountability to become the norm after gender violence. It's time to pass the Equal Rights Amendment.
You are a lawyer who is asking for the state to represent individual citizens in criminal proceedings. You are a lawyer who thinks the Equal Rights Amendment will instantly create a panacea for the scourge of a complete lack of legal recourse in the realm of sexual violence in the United States. Got it.
So that our legal system can become a system of justice, and Me Too can finally become no more. Thank you.
The Constitution is flawed because, as it stands, there are no laws, protections, or recourses under federal law in regards to sexual violence. Oh, well, except for Title IX. Oh, and Title VII of the Civil Rights Act of 1964, which makes sexual harassment a form of sex discrimination and thus a federal crime. Oh, and the Violence Against Women Act of 1994. Oh, and USC 18 regarding sexual abuse in prisons or via the interstate kidnapping of children or female genital mutilation. Oh, and 10 U.S.C. 920, Article 120, in regards to the criminalization of rape and sexual assault in the military. Yes, the Constitution, as currently constructed, means that none of these laws actually exist, which is why we need to revise our criminal justice system to look more like the Old West, so that there is no insulating authority between the accused and the accuser in criminal matters. And the mechanism that will fix all of this? The Equal Rights Amendment. Which is why I say, yeah, go ahead and ratify it. No, seriously, make it law. Make it federal law that all women and men have to be afforded equal standing under the law, in the workplace, in family court, in prisons, and in the military. By all means, ratify it. Let there be no gray area any longer for anyone, whatever their genitals, under the law. It likely won't do what our speaker says that it will do, but it may indeed end up doing a lot of good. And, at the very least, it will make everything a bit more equal. As always, thank you for watching.